Good evening and welcome. Thank you for joining us today for this discussion. My name is Fay Hartog-Levin. I'm a member of the board of the Chicago Council and a distinguished fellow here. The Council aims to foster a deeper understanding of global affairs, and we're honored to have Judge Chile Eboe-Osuji with us tonight to discuss the role of the International Criminal Court, the challenges of holding leaders accountable for serious crimes, and the evolving landscape of international justice. The judge served as president of the International Criminal Court, the ICC, from 2018 to 2021, and presided over numerous cases involving war crimes and crimes against humanity. He was born in Nigeria and earned a Bachelor of Laws from the University of, Calabar in Nigeria, a Master of Laws from McGill University in Canada, and a Doctor of Laws from the University of Amsterdam in the Netherlands. I told him I thought he was a student of the world. Prior to his ICC presidency, he served as a judge at the court from 2012 to 2018. He has also held senior positions at the International Criminal Tribunal for Rwanda and the Special Court for Sierra Leone. Currently, he's a distinguished international jurist at the Lincoln Alexander School of Law at Toronto Metropolitan University and is the author of End of Impunity, Holding World Leaders Accountable for Aggression, Genocide, War Crimes, and Crimes Against Humanity. The judge will be available to sign his book immediately following the program. We'll start off today's program with a discussion, after which we'll have time for Q&A with the audience. Please hold your questions until the Q&A portion of the program, and you'll be able to ask your questions directly. For those joining virtually, you can submit your questions online at CCGA Live. Before we begin, I'd like to remind everyone that today's program is on the record, and any views expressed by speakers we host here at the Council are their own and do not reflect any institutional positions. With that, we'll start with our first question, and please silence your phones. Judge, could you give us an overview of what the distinctions are between the International Court of Justice, the International Criminal Court, and the various criminal tribunals that are in The Hague?
Thank you very much, Ambassador, for having me here. It's a great honor and privilege for me to be with you and with our wonderful audience who took time out this evening to come and listen to the discussion. Yeah, the question, of course, is an important one because we often hear about The Hague whenever we talk about administration of justice, be it criminal or civil. So we hear about The Hague. And The Hague is the city where you have both the International Criminal Court, the ICC that I served, as well as the older court, the International Court of Justice. Now, there are other international tribunals that have worked there or still do, some are closed. Now, I think, let me split it in half. There is a criminal work that gets done, administration of international criminal justice. That's one half of the equation. An international criminal court is part of that, together with what we call the ad hoc tribunals, like the tribunal that processed the Rwanda genocide in 1994. That's the International Criminal Tribunal for Rwanda. Also, the tribunal that dealt with the former Yugoslavia, atrocities committed there, International Criminal Tribunal for the former Yugoslavia, so a special court for Sierra Leone. So they belong to what the ecosystem of the international criminal justice. That's one side. But on the other side is the International Court of Justice, the ICJ. The ICJ doesn't necessarily deal with international criminal justice in a direct way. The ICJ deals with disputes between states. But in those disputes between states, there can be questions of criminal law in it. But it arises in the sense that, for instance, Belgium once wanted to prosecute a former foreign minister of the DRC, Democratic Republic of Congo. And DRC sued Belgium at the ICJ, saying, no, you cannot do that because our foreign minister enjoys immunity. And the object of that kind of litigation was for the ICJ to tell Belgium, no, you cannot do that, stop it. So that's a different question from international criminal justice you do at the ICC, where the object of that is accountability to punish somebody with criminal penalty for violating international criminal norms. So ICJ does not engage with that kind of question. The ICC does. Now, in the work of the ICC and the ad hoc tribunals, the responsibility is individual. It's got nothing to do with states. So I could be the head of state of, say, Nigeria, where I was born, or Canada, as the case may be. If I'm being prosecuted at the ICC, responsibility is individual on me. It got nothing to do with my state, even though I might be doing something in the name of my state. But the responsibility is not on the state at the ICC. So it's individual, purely so. Whereas at the ICJ, responsibility is on state, whether a state has lived up to its international obligations. So in a nutshell, that would be, I hope that makes sense, the difference between the two streams of international justice.
And so how do the ad hoc tribunals relate to the ICC?
Very important question. The ad hoc tribunals were created, as the name suggests, ad hoc, to deal with specific issues. It could be geographic area, it could be a time frame limitation. For instance, the Rwanda tribunal, where I worked as well, had jurisdiction for what happened in Rwanda in 1994, from the 1st of January 1994 to the 31st of December 1994. In there, anything that happened in Rwanda, the tribunal had jurisdiction over. And people who did something in Rwanda during that period, the tribunal had jurisdiction over that. But the tribunal could not at large prosecute somebody who, say, committed a crime in Sierra Leone. Yeah. The ICTR couldn't do that. So that's one difference. In the Yugoslavia tribunal, more or less the same thing, although its own time span was a little longer, but it focused on the nationals of certain countries nominated as such. Whereas the ICC has a global jurisdiction. It's not time, it's not limited, except that from 2002, when the ICC came into operation, anything that happened from then on the territory of a state party to the Rome Statute, the ICC would have jurisdiction over, or done by nationals of a state party to the Rome Statute, ICC would have jurisdiction over. So it is global. As we speak, there are 124 states that are parties to the Rome Statute. So that's one difference between the ICC. It's permanent. It is not ad hoc. It is there forever, operating since 2002, whereas the ad hoc tribunals had a more limited, focused jurisdiction over territories, people, and time frames. Another reason why it's important to have the ICC relative to what the ad hoc tribunals were doing was because it typically would be the UN Security Council that would create these ad hoc tribunals. So it was for the Rwanda tribunal and the Yugoslavia tribunal. And it takes a lot of efforts to do that. So every time there's a new issue for the UN Security Council to get going with questions of veto and all that, it's also more expensive. So the concept of ad hocism became a problem for international relations statesmen and women at the time. So they said, we don't want to be doing all this ad hoc thing all the time. There's a new issue. Why don't we have a permanent court that will deal with all these questions from now on? So that's why ICC was created.
So the jurisdiction of the ICC is derived from the Rome Statute.
Yes.
But the ad hoc tribunal's jurisdiction comes from the UN?
Generally speaking, yes. I mean, there are also other ad hoc tribunals that got their jurisdictions elsewhere. There's one for Kosovo, for instance.
Kosovo, yeah.
Came from, I believe, the European Union or the organization, basically European Council,
Yeah.
Could do that. Okay.
So you mentioned that there are 124 countries that are party to the ICC, but there's some very notable big exceptions.
Absentees,
the United
yes.
States is not one.
Yes.
And Russia's not one.
China is not one.
China's not
India.
one. India,
Indonesia.
and we could go on. So Turkey.
Yes.
Another one. Israel.
Israel, yes.
Yeah. So we've had the ICC take action against Netanyahu, but Israel's not a party to the ICC. How does the ICC exercise jurisdiction over Netanyahu?
Thank you. We need to expand that question to also recognize that it's not only Mr. Netanyahu and Mr. Gallant that the ICC is interested in. There are nationals of states not party to the Rome Statute. The same goes for Russia. ICC is also going after Vladimir Putin and 5 of his senior colleagues in government. And Russia is also not a party to the Rome Statute. The leader of Myanmar, Aung San Suu, I think is his name, ICC is also going after that gentleman, and Myanmar is not a state party to the Rome Statute. So it isn't only Israel that's in that, that has that feature to what's going on. But how does the ICC get jurisdiction over these, what's happening in relation to these individuals? The provisions in the Rome Statute that directly give ICC jurisdiction in terms of saying that the ICC would have jurisdiction over what are crimes, international crimes committed on the territory of a state party to the Rome Statute, or a party that may not be a state party to the Rome Statute, but a party that had declared recognition of the jurisdiction of the ICC. Things that happen on the territory of those states, the ICC would have jurisdiction over. So it is for that reason that the ICC has claimed jurisdiction over over Russian nationals, Vladimir Putin and his colleagues, because of the war in Ukraine. Ukraine had declared before the war started in 2002 that it recognized the jurisdiction of the ICC over what happened since 2014 in Ukraine. So that was a starting point. But now Ukraine has itself joined the ICC. So on that basis, ICC exercises jurisdiction over what happened on the territory of Ukraine, regardless of the location of who or the nationality of who committed those crimes. So that's one.
And so going back to the Israel,
the same question.
How is the jurisdiction derived there?
Because the state of Palestine is a member state of the Rome Statute. Because of that, what's happening on the territory, the occupied territory of Palestine, is a matter for the ICC's jurisdiction. The same with Myanmar. The Myanmar argument is a bit more involved in the reasoning that the judges used. But what happened there was that you had Rohingyas being subject to what happened to them in Myanmar, and it was characterized as forced deportation, right? But the effect of that was that the Rohingyas now poured into Bangladesh. That is a member state of the Rome Statute, and the judges reasoned that that had an effect on a member state of the Rome Statute, and that gave the court an anchor of jurisdiction over Myanmar.
And the court's subject matter, if that's the right expression, deals with war crimes, crimes of aggression, genocide, and crimes against humanity. Do you think the Rome Statute should be expanded or changed in any way?
The Rome we have to, Ambassador, acknowledge that the Rome Statute and the ICC are necessarily human institutions, and anything human beings created could always use improvement. So it is not a perfect system. There are ways in which the Rome Statute could use reform. One specific way would be this. The crime of aggression, for instance, when the ICC was created, it became, for some reason, a contentious question whether the ICC should be given jurisdiction over the crime of aggression in a way that is not controlled by the UN Security Council. In other words, the Security Council would not have a trigger for the ICC's exercise of its aggression jurisdiction. So that was a debate. Some states said no. The idea of an independent court means you cannot have a political entity, the Security Council, have that trigger over what the ICC can do in relation to the crime of aggression. But that debate continued. But the way they resolved it was to say, okay, well, we are going to give ICC jurisdiction over the crime of aggression, but not in relation to the crime of aggression committed by states that are not party to the Rome Statute, except when the Security Council authorizes that. So in some kind of tortured way, it ends up being the Security Council being given the jurisdiction, the authority to allow aggression jurisdiction to be exercised over nationals of states that are not party to the Rome Statute. Now, the funny thing is that was the only crime in the ICC Rome Statute that has that kind of restraint on it. Genocide, crimes against humanity, war crimes do not have that rider to them. It's only the crime of aggression that says, well, yes, you can exercise jurisdiction, but not over nationals of non-state parties, except when the Security Council authorizes that. So that is one problem we have. Now, that had created a real problem when Russia invaded Ukraine. That became a real issue. Okay, yes, the ICC could prosecute Russian soldiers and Russian officials for genocide on the territory of Ukraine, war crimes on the territory of Ukraine, crimes against humanity on the territory of Ukraine, but not the crime of aggression on the territory of Ukraine. So the states were now scrambling, should we create a new ad hoc tribunal just to deal with the aggression crime? And that debate is still ongoing. It goes up and down, and would run as a will to make it happen. So that is one problem we have in the Rome Statute. So one way to reform the Rome Statute would be to equalize the norms of jurisdiction so that it is the same for all crimes. So you don't have this exception that has been made for the crime of aggression. Remove that exception so that aggression is on the same level as genocide, crimes against humanity, war crimes. So that is one amendment the Rome Statute can use.
What was the rationale for excluding the crime of aggression from the same jurisdiction?
Well, to put it bluntly, the crime of aggression is a crime more powerful states are better in a position to commit. And that's one issue on which the 5 permanent members of the Security Council were agreed on that.
You see. I get it. I know that there's been criticism of the ICC. Recently, the Trump administration criticized the court for being biased and politically motivated. Can you comment on that?
There is, let me put it this way, there is no merit to that charge at all. Of course, it was done in the context of ICC process against Mr. Netanyahu and Mr. Gallant. The difficulty with that argument is that you have to ignore the fact that the ICC has a process against the Russian nationals, including President Putin. You have to ignore the fact that the ICC still does have a docket against the leaders of Kenya. The president of Kenya, Uhuru Kenyatta, was subject of investigation, prosecution of the ICC. So was and still is the current president of Kenya, Mr. Ruto, right? These people had been subject of investigation and prosecution at the ICC. You have to ignore the fact that the head of state of Sudan, Omar al-Bashir, had been prosecuted, is a subject of investigation and prosecution at the ICC. You have to ignore the fact that Mr. Jean-Pierre Bemba, who was a former vice president of the Democratic Republic of Congo and also senator in Congo, was prosecuted at the ICC. You have to ignore the fact that Mr. Laurent Gbagbo, the former president of Cote d'Ivoire, and one of his ministers were prosecuted at the ICC. So you have to ignore all of this to say, well, because the ICC is prosecuting, or rather, issued arrest warrants against Mr. Netanyahu and Mr. Gallant, leaders of Israel, ICC is biased. Well, the argument has to be by a parity of reasoning that every other state whose national the ICC is going after, the ICC must be biased against them. And that is not a serious argument to make. From my perspective, the only bias that you can legitimately attribute against the ICC is bias against injustice. That is the only bias we can say it has, and that's the right bias.
And just to finish up on this topic, when the ICC does come to the conclusion that there's been one of these violations, as in the Israel example, there's no jurisdiction until the people go to a country that is a party to the Rome Statute to exercise jurisdiction over the people?
Yes, indeed. So that's a question of how do you arrest those individuals. Yeah. Remember, here we're talking about individuals, not states, in order to subject them to the processes of the ICC. The obligation to arrest anybody that is subject of an ICC arrest warrant is an obligation on only states parties to the Rome Statute. States that are not parties to the Rome Statute do not have that obligation. It's for that reason that Mr. Omar al-Bashir of Sudan, when he was president of Sudan, when he was being sought after by the ICC, was able to travel around, especially within the African region, some states that were not parties to the Rome Statute. He would go there. Sometimes he would actually travel to states that are parties to the Rome Statute, but those states, realizing their obligations, would tell him, hang on, we have an obligation now, and then he will again leave for finishing the business. So yes, it is on the obligation to arrest is only on states that are parties to the Rome Statute. Other states who are not parties to the Rome Statute, it's up to them to decide whether they want to do that. So, but there's one important point I should have made when you asked initially about the ICC. It's important to recognize, to remember that the jurisdiction of the ICC is not automatic in the sense that someone has done something, ICC jumps in and prosecutes them. No. The ICC is only a court of last resort. The ICC comes in only as a backstop to ensure that justice is done somewhere. The primary obligation to do justice is on states themselves. So that's spelled out. Any state that is troubled by the process of the ICC has the right to say, okay, ICC, you don't need to worry about this. We are going to do it ourselves and watch us do it, and not just claim that we will do it and not do it. But once they start doing it genuinely, the ICC cannot exercise jurisdiction. It's just that simple. The only time ICC enters in this jurisdiction is when a state or states that should exercise that primary jurisdiction don't do it, are unable to do it, or unwilling to do it. Remember here, there are two considerations. Oftentimes people will say, well, how can you go after the leaders of this state? That state has robust judiciary, functioning judiciary. That's not the question. There are two equations there. Are they able? So you can say, well, a state that doesn't have a functioning judiciary will not be able. But there's a second calculation, which is, are they willing to do so? You can have your robust functioning judiciary, but if you don't do that justice, you've been unwilling to do it. So that gives the ICC jurisdiction to proceed as well.
Does the ICC have to make a demand of the other state to do something, and if they refuse, then intervene?
Not necessarily. There's no obligation. It's not a prerequisite.
Okay.
Of course, good practice might recommend that, but it's up to a state to do it themselves. When justice cries out to be done, everybody sees that need. It needs to be done by those who should exercise that jurisdiction. If they don't, then of course, they can't say, well, because you didn't ask us to do it, you cannot have jurisdiction. No, you should know what to do.
Yeah. Tell us a little bit about your book. I know that the subtitles sort of reflect the areas of jurisdiction of the ICC. What made you write the book, and what were your lessons learned?
Well, thank you. The book came out of a long period of reflection on the question, as well as having to deal with it in the processes of my work, which I started doing in 1997 when I was prosecuting at the Rwanda Genocide Tribunal. The question of immunity will keep coming up, popping up and down, in and out. And at the Special Court for Sierra Leone, it was more focused in the sense that the statutes of the Special Court for Sierra Leone, as did the Tribunal for Rwanda, provided that there is no immunity for anyone, including for heads of state. So that was not tested really at the Rwanda Genocide Tribunal. But at the Special Court for Sierra Leone that had the same provision, it was tested in the sense of there was a process against Charles Taylor, the former president of Liberia, and his lawyers argued that because he was the head of state, the court could not prosecute him. So the appeals chamber of the court, Special Court for Sierra Leone, dismissed that objection and reasoned that even beyond the text of the statute of the Special Court for Sierra Leone, the same as the Special Tribunal for Rwanda, beyond the text itself, the Court of Appeal, the Special Court said, well, international law has never even recognized immunity for heads of state before international tribunals. So that generated a debate amongst scholars. when I was at the ICC myself, the question came centrally to two cases I was working on. Again, research had to be done, and to deal with that, again, we ruled that on two occasions that there was no immunity for heads of state before the ICC. But some scholars continue to debate that question. I formed the impression that these were scholars who had not really studied that question from close up. If you had lawyers who are in the courtroom, an international court, and judges dealing with a question specifically, it's too much for some general international lawyers who are doing all sorts of things just to, drop in sometimes and express robust views on the subject. So I thought maybe it's time to write a book and tell the story that started in 1919 when on the conclusion of the First World War, the leaders of the most powerful states at the time, France, led by Georges Clemenceau, UK, led by David Lloyd George, these are prime ministers. You had the premier of Italy, Vittorio Orlando, and Woodrow Wilson himself at Versailles Peace Conference decided that there would be no immunity for heads of state. Why? Because they wanted to prosecute the Kaiser of Germany, the most powerful European leader at the time of the First World War. And they said, okay, from now on, we want to make it very clear to the world that regardless of how powerful you are, how high you are in political office, if you commit an international crime, you will be prosecuted. So that project started with the Kaiser. It didn't quite work. They didn't get the Kaiser to prosecute because he went on asylum in the Netherlands, and the Dutch did not surrender him for trial before an ad hoc tribunal that the leaders of allied states wanted to set up at the time. But the genie was out of the bottle. The fact that you had Article 227 of the Treaty of Versailles that publicly arraigned Wilhelm Hohenzollern, the Kaiser of Germany. Article 227 of the Treaty of Versailles. So this story was, okay, let's dig deep into what went into what was a discussion that resulted in Article 227 of the Treaty of Versailles. So tell that story. It was a pointed, deliberate action. It was not a footnote in history. It was the main thing at the time they wanted to see happen. And fast forward that to the Second World War, conclusion of Second World War in Nuremberg. You had the Charter of the Nuremberg Tribunal, Article 7 of that charter, 1945, said there was no immunity for anyone, including heads of state or heads of government. So that was a template to what we have in the Statute of the Special Court for Sierra Leone I mentioned earlier, as well as the Statute of the Rwanda Tribunal and the Yugoslavia Tribunal, as well as Article 27 of the Rome Statute. So all that comes together in the story of how did we get to this point? And the result is a book titled End of Immunity.
Interesting.
Thank you.
Can you share with us, before we go to Q&A, some highlights of your presidency of the ICC and some of your less favorite moments there? Some personal stories.
I would say perhaps both in the, let's roll it up in one, something that has both less favorite moments as well as moments of accomplishment that's what I'm talking about. It relates to a topic something you touched upon in your questions about the allegations of bias. When I was at the ICC, soon after I arrived, there was tension in the air, palpable, more than even tension. It was you had this problem between African leaders of the African Union, some of them, not all of them, and the ICC. And the complaints they had was that the cases at the ICC, all of them at that time, 100%, were all from the African region, from the African continent. And the African leaders were going, hang on, what's going on here? When this court was created, we embraced it with enthusiasm. We rushed out because we wanted to see justice in the world, everywhere. Now we turn around and it looks like the only time the court recognizes it could do justice was when the cases coming out of Africa. So because of that, there was now a cooling off, more than a cooling off of interest of some African leaders. There was actually a movement of mass withdrawal so that African states would pull out en masse. And that would have led to the collapse of the court because the Africa group has the highest subscription rate to the court, 33 states. And so that was what I met at the time. And it was disturbing. You could see their argument intellectually, but at the same time, you could see that argument wasn't what the court was about. The court was about justice for victims of atrocity. It wasn't about giving succor or protection to people who are accused of victimizing those people. And my argument was saying it looks like we got it all wrong here. I do not see African victims of these events complaining that the court was focusing unduly on their plight. Did you ask African victims of atrocities their views before you start this mass withdrawal movement? Of course not. So my argument was, hang on, the African leaders should be bold enough to ride Martin Luther King's maxim of injustice anywhere is a threat to justice everywhere, and insist that the ICC should expand its work to cover everywhere. But that cannot be an argument to say let's pull out or weaken the court because the court is not yet doing its work everywhere. So you had that, allegations of bias. I opposed it. I disagreed with it robustly. And when it became my turn to lead the court, I made it a priority to bring African states back into the fold and to calm down that anxiety for mass withdrawal. And it's for everyone to say whether or not still. I'd like to say that we know that anxiety has calmed down since then till now. So that would be one thing that I'd like to talk about. But then you can also see it came from a place of anxiety as well.
Oh, big challenge that you handled. We have some questions from their online audience, which was, and I'm not sure if I understand the question, but perhaps you do. It says, well, how does the issue of a nation state signing but not ratifying the Rome Statute play into the prosecution of a world leader so as to treat the issue of impunity? Is it possible that somebody has signed but not ratified?
Well, in international law, it's not enough to sign a treaty. You also have to ratify it. Signing a treaty is something you do when all of us here, let's say we're in a conference to adopt an international treaty. After 2 days or 2 weeks or 2 months of negotiating it, we produce a text. that we all debated it. So signing is to say, yes, indeed, this is the text we came out of at the end of the meeting. So in principle, it's okay. But us saying in principle it's okay doesn't mean that we are yet parties to that. We have to take this treaty back home. In the U.S., you need Senate ratification. Yeah. So it is with many other states. So they need to take. So it's not enough to sign the treaty. You also have to ratify it. You only become a member and bound by the obligations of that treaty and the rights it imposes if you've actually ratified it. That's the second process. So you cannot exercise jurisdiction merely on the basis of having signed. You cannot endure an obligation or exercise a right under a treaty merely because you've signed it.
So it's as if it didn't happen.
Yes.
Yeah, got it. We have another question. Why has the ICC, do you think, why has the ICC not brought a case against the current leaders of Hamas for the inhumane treatment of the hostages?
I would like to think that was one of the arrest warrants. Sorry, that's the second part of the arrest warrants that the Mr. Khan sought. If you remember, and that's what resulted in the so-called false moral equivalency argument, which I think is also, in my view, not a sustainable argument to make this thing about false moral equivalence. Somebody can ask me why I think that, but to deal with that, it's about that, because the Mr. Khan, the chief prosecutor, sought an arrest warrant for both Hamas leaders as well as Mr. Netanyahu and Mr. Gallant. So the Friends of Israel as well as Mr. Netanyahu deploy that argument to false moral equivalent. How dare you equate us with the leaders of Hamas? So that goes to that question, doesn't it?
Yeah, and I guess the other part of the question is...
the problem was that, of course, the idea for operations ended up killing a lot of those, if not all of the persons that the ICC was seeking to arrest on the side of Hamas.
Oh, okay. And I guess the question that goes with that is that Israel has a very active judiciary. And so why did the ICC act?
But that goes to what I said earlier. It's not enough to have a very robust judiciary. You have to deploy that judiciary to do the kind of justice the Rome Statute contemplates. It's not enough to say, well, we prosecute our own leaders who, for corruption, it's not quite the same thing. Prosecuting your leaders for corruption against your state, it's not the same thing as prosecuting your leaders for violation of international criminal law, especially when that is done against people you consider the other side. So it's not quite the same thing. So we have to see that the Israeli judicial system has been put to use in prosecuting and investigating genuinely questions of international criminal law that arise in this conflict between Palestinians and Israelis.
Before we turn to the audience for questions, is there anything that I didn't ask that you would have liked to have answered?
Yeah, I think we can let the audience. Let's
right.
Give the audience a turn.
Can we have some lights to? We're going to have the microphones passed around. We need some lights. Okay. Do we have runners with the microphones? Want to just start here? And please identify yourself.
I'm Jane Keene. I'm wondering if the International Criminal Courts has an enforcement arm. What if you have an individual who you are going to prosecute for, say, war crimes or crimes against humanity, and he just ignores you?
And that's a very, very important question that goes to the core of of what often comes up about how effective it is whole thing anyway. I think that's that. ICC does not have an enforcement arm, and the states, it has always been like that for international institutions. They really don't have enforcement arms as such. The international institutions, especially the courts, so the same question goes for the International Court of Justice and all the other international courts that exist out there. They depend on states for enforcement. Now, with the ad hoc tribunals, the Rwanda Genocide Tribunal, the former Yugoslavia Tribunal, you had the Security Council was the organ that created them, because the Security Council is the enforcement arm of the United Nations. In a sense, that would give those tribunals a greater torque, greater traction than the ICC and the other tribunals that are not created by the Security Council. So for that reason, you tended to see more respect for the processes of the ad hoc tribunals, Rwanda Genocide Tribunal and the former Yugoslavia Tribunal. So they got more of their processes respected because of that concern that if somebody ignored their mandate, their order, then they get referred to the Security Council. Although that was always theoretical, but that fear was enough to give them a greater purchase. It was more theoretical in the sense that you still had veto power at the Security Council. And we know that when the ICTY, the Yugoslavia Tribunal, was operating, the Russians did not like it at all. So nobody tested the proposition, should we, take a question of enforcement to the Security Council, see whether the Russians would veto it. But the point was that the Security Council gave greater backing to the ad hoc tribunals, the two ad hoc tribunals, than does the ICC. ICC now depends on states who are member states to enforce its orders and warrants.
We have somebody right here in the front.
Thank you. That's kind of corollary to her question. And Mongolia hosted Vladimir Putin last year, but the president said, I can't arrest him because our country depends too much on Russia. That's one question. The other question is kind of a historical question. What were the motivations for countries to sign the what's called Rome Statute? What are the motivations for countries not to join or not to sign the Rome Statute? Thank you.
Thank you.
Thank you. You could see very well that a lot of my answer to that, the second part of the question, of course, you know that Mongolia, you're quite correct. Mongolia did not arrest Mr. Putin when he went there. And they said, look, perhaps the pain of arresting him will be more than our obligation to the Rome Statute. So that's the choice they made. It means that they're in violation of their obligations under the Rome Statute. But putting that to the side, what are the motivations for countries that signed and what are the motivations for countries who did not sign? To an extent, one could see certain elements of speculation about it. But if we had to look at the declarations that states made when they were negotiating the Rome Statute, when even in the lead up to the negotiation of the Rome Statute, the argument as stated has been this, and you see that in the text, the preamble to the Rome Statute. They said, look, these crimes we are providing for here have been a scourge on humanity since time immemorial. these crimes of genocide are not new. War crimes, crime of aggression, crimes against humanity, they've been committed all through history. So they've been applied on humanity, and we cannot continue to allow humanity to suffer bad blight. It's time now for us to do something about it. We still hope that states can live up to their primary obligation, which they've not done all along, to prosecute these crimes. But we're now putting in place a court of last resort so that when states don't prosecute, don't do justice, then there is a last place of call that we hope can do justice. So that is what they declare, those who joined. Okay, so that's a general shared motive for those who are members of these treaties. Some of them genuinely believe it, but we can ask whether that's really the case. Some of them also know that that's one way they also can protect themselves. A lot of the states who are parties to that treaty, not all of them, but many of them are not states you would consider to be strong or militarily strong, who want necessarily to spend their money arming themselves against the next war. So is it possible for us to join together in the same way, according to Thomas Hobbes, human beings agree to form, state societies, give, the access of their authority to one central authority to protect everyone, so it's not up to individuals to do it themselves. So that is one motivation for some of the states. Another motivation for some of the states that joined the Rome Statute. On the other hand, the states who have not joined, some of them will think, well, we are powerful, we have all the might, we don't need the law to protect us. We can use weapons to do that ourselves. So that could be one consideration you have there. And there are also some who would go, well, she hasn't joined, why should I join? So there's some of that, they're all over the place. So I hope I've answered the question. Thank you.
Is there someone in the back? Oh, over here, maybe? Thank you.
Hi, I'm David Kinsey. Thanks very much for being here. I guess I'd say, if you look just over the last few weeks, you could argue that there's been a bit of a deterioration in the international rules-based order. A lot of people believe that to be the case. To the extent that that is the case, what impact might that have on the ICC in terms of its sway, perceived legitimacy, and ultimately its effectiveness? And what do you see as kind of the trajectory of the ICC in this kind of new world that we perhaps find ourselves in?
Thank you. A very, very great question, as all the others happen. These developments you mentioned, of course, we're all seeing it. There's not only many people see that concern, regression in the rules-based order we're experiencing. I'd like to think that that's not the first time the world has seen this sort of thing. I do think that there are bumps in the historiography of human international relations when you have these sorts of things happening. But I also like to believe that it is in those times that it is up to the people of the world and those who care enough to insist, no, we're not going to just roll over and let the forces that don't want the rule of law to prevail, for those forces to have their way, that we have to hang in there and keep resisting that tendency to erode the rule of law. So the question you ask, what can the ICC do? It's not about the ICC or an international institution. It is about us. the citizens of the world to feel that, look, we do have a stake in this. Do we care about the plight of humanity? If we do, then the ICC was set up and other institutions set up to sustain the norms that would make us different from animals in the jungle who, consume who they can when they can. Now we're different from that. So it's up to us to insist on that correct behavior. People often reference legitimacy of the ICC, how all these things weaken the legitimacy of the ICC, how, like the question from the gentleman up there who said Mongolia, for instance, did not live up to its obligation to arrest. You have some Western leaders who are saying the same thing. Well, because certain person is our ally, even though they are under arrest warrant, we will not arrest them when they come. But then the same person will turn around and say, well, but the other person is not our ally, so ICC should go after them. So these are people who say, what about the legitimacy of the ICC? The question is, that is not really about the legitimacy of the ICC. It is about the illegitimate conduct of people or heads of state who do that sort of thing when they know that international institutions were created not to be self-enforcing. International institutions, by definition, depend on states to enforce it. So it's a two-sided agreement. The international institution will lead the way according to its mandate to point to this is what needs to be done. But then everyone understands that states parties or states will bring it home by saying, yes, we established this institution to lead the way. When it leads the way, we are going to back it up and do what we need to do. But then you have this institution lead the way and everybody starts backing out. So it is the institution has done its best what it was created to do. The ICC was created to issue arrest warrants against Mr. Netanyahu, against Mr. Putin, against Omar Bashir, against the leaders of Kenya and elsewhere. They've done that. So it's for states now to live up to their own obligation and follow and do their own part. So it is not a legitimate question for the ICC. It is a legitimacy question for those states that refuse to live up to their own part of the bargain.
I think we have time for one more question. We have one over here.
Hi, my name is Kenneth Newman. Two quick questions. Were the ICC statutes originally based on the Nuremberg trials? And is there still evidence being gathered for Sudan?
Answer to quick questions, yes, yes.
Very quick.
Thank you.
That's great. Thank you so very much.
You're welcome.
Judge. It's been a very enlightening conversation, and we appreciate your time.
Thank you for having me.
And if you will, you can meet some more people at the book signing table after this. Thank you all for your attention and for being here. We appreciate your being here. Thank you.